Section 1. Diplomatic immunity. A primer. Diplomatic immunity. Sounds fancy, right? Like a get out of jail free card for diplomats behaving badly. Well, not quite. It's more nuanced, more like a diplomatic incident avoidance card. This legal principle ensures diplomats can do their jobs without fear of harassment or pressure from the host country. Imagine an ambassador constantly worried about being sued or arrested. Tough to negotiate a trade deal from a jail cell, right? Diplomatic immunity prevents that. Now, this immunity isn't a free pass to break the law. It's about protecting diplomats from politically motivated prosecution, ensuring they can represent their country effectively. Think of it as a necessary evil, a delicate dance between respecting a nation's laws and ensuring the smooth functioning of international relations. In Section 2, Libya versus Islamabad, the case of the disputed property. Picture this. Pakistan 2024, the State of Libya takes a civil judge in Islamabad to court. Reason: a property dispute, naturally. Libya claims ownership of a building in Islamabad. Used orthoped tes mortius as geisas to send geisazari the zayatiu quarantine disnanda and the Libyan Embassy's commercial section. But here's the twist. The Pakistani court ruled against Libya, citing the properties used for commercial purposes. Libya cried foul, invoking diplomatic immunity. This, my friends, is key. Beware the things get juicy. The Islamabad High Court had to decide, does diplomatic immunity apply when a property technically owned by a diplomatic mission is used for commercial activities? Buckle up, because this legal showdown is about to get real. Section 3. Untangling the threads. Diplomatic functions versus commercial activities. The crux of the Libya versus Islamabad case hinges on one key distinction: diplomatic functions versus commercial activities. Diplomatic immunity, as we've established, protects diplomats while they're attending state dinners, negotiating treaties, that sort of thing. But what about when a diplomatic mission dabbles in business? The Islamabad High Court drew a line in the sand. Diplomatic immunity, they argued, doesn't extend to commercial transactions. Why? Because these activities fall outside the core functions of a diplomatic mission. Think of it this way: if an embassy sells souvenirs, they're acting like a business, not a diplomatic entity. And businesses, even those owned by embassies, are subject to local laws. Section 4. The immunity waiver, a diplomatic tightrope walk. Now here's where it gets even more interesting. Diplomatic immunity isn't absolute. It can be waived. Yes, waived. Think of it as a get out of jail free card that comes with a tiny asterisk. A sending state can choose to waive the diplomat's immunity, essentially saying, go ahead, prosecute them. This waiver, however, must be explicit and unambiguous. No ifs, ands or buts. In the Libya versus Islamabad case, Libya argued they never waived their immunity. The court, however, found no evidence of such a waiver. This means Libya unknowingly subjected itself to the jurisdiction of Pakistani courts by engaging in commercial activities. Ouch. Section 5. The verdict and its echoes in international law. The Islamabad High Court's decision in the Libya versus Islamabad case sends a clear message. Diplomatic immunity is not a blanket protection for all activities undertaken by a diplomatic mission. When a diplomatic mission steps into the world of commerce, they precise. They play by the rules of the host country, just like everyone else. This ruling has significant implications for international law. It underscores the principle that diplomatic immunity is not a license to operate above the law. It reminds us that even in the world of international diplomacy, the lines between diplomacy and business can blur, and when they do, the law of the land prevails.